My name is Judge Bryant, and I am presiding over this case. Oh, I forgot to get your name. Mr. You said Krayshawn. This is horrible. Sir, get your ear away from that camera.
I cannot. I'm sorry, Your Honor.
Sir.
I'm so sorry.
Let me tell you something.
I cannot.
You need to come in person. No, you can't hear because you're.
I'm not trying to upset you, Your Honor. I just can't hear anything. That's the only way I can hear you is up there.
I need Miss Page to be still. I need Miss Page to sit up properly in the camera and to be still, please. All right. The complaining with. I always wonder why people don't turn off their camera when they want.
Can you hear me?
We can, sir. I really need you to get somewhere and be stationary.
Okay, I had to move to a different area, that's all. Go ahead.
Well, thank you for your permission.
Judge Bryant sure has her hands full today with a group of students that needs a lesson in courtroom etiquette. These 3 defendants are not following the rules of courtroom decorum, so it's time for her to take these 3 defendants to school. They all seem to have missed the memo on how to conduct themselves in front of the judge on Zoom. And Judge Bryant has got 3 simple rules for them. Get stationary. That means sit up straight, stay seated, no fidgeting or wandering around, and be ready to attend court. The first defendant kept interrupting when it's not his turn, and then putting his ear up to the phone when it was. The second defendant would not sit up straight in her chair and look at the camera. And the last guy was just wandering all around his room. Will these 3 defendants learn their lessons today? Well, we all are about to get a crash course in courtroom decorum from the Honorable Judge Bryant. Stay tuned and subscribe to our sister channel Crime Time 365.
Mr. Flanagan, can you see if the Howard case started as a felony, please?
No, Your Honor, it did not. On the proceeding April 14th, Ms. Stevenson is listed as the attorney. So,
you all.
Oh, there you go.
You all must.
Turn your volume up.
Sir, why would you? This is ridiculously ignorant. Okay. Somebody must have transposed the P numbers.
right, that's what I'm thinking. Yeah.
All right.
I'll fix it.
Thank you. All right. Good morning, ladies and gentlemen. When prompted to do so, please unmute and state your full name for the court. When prompted to do so, unmute. I said when prompted to do so. This person on this Tino, you are so disruptive to my court proceedings today. You've been disruptive all morning. You've been disruptive all morning. You have been disruptive all morning. Ms. Howard, I'm going to send you to a breakout room to speak with the lawyers. Please accept to join breakout room number 6, Ms. Howard. The person identified as Teresa, please unmute and tell the court your name.
I'm Teresa Bragg.
Teresa Bragg. Ms. Ritter, is this your witness?
No, I'm on the same case.
No, ma'am, I'm not speaking to you, please. Hold on. Ms. Ritter, Ms. Ritter.
Judge, I don't have Ms. Bragg on my list.
All right. Mr. Coger, state your name for me, please.
Michael Coger.
Thank you. Now, the disruptive person on this TNU U616AT, please unmute and state your name.
Can you hear me, Ayana?
and state your name. I've been hearing you all morning and I haven't wanted to. Please state your name.
Clarence Reeses.
Everyone, please start your video. Oh, I forgot to get your name. Mr. You said Krayshawn. This is horrible. Sir, get your ear away from that camera.
I cannot, I'm sorry, Your Honor.
Sir.
I'm so sorry.
Let me tell you something.
I cannot.
You need to come in person. No, you can't hear because
I'm not trying to upset you, Your Honor. I just can't hear anything. That's the only way I can hear you is up there. I mean, it's unmuted and everything, and that's the only way I can.
Whew, this is blessing me. Let me put him this message is only to him. This message is not to the rest of you all. Okay, I'm getting ready to put up a message and it's only to him. All right. He's not even looking at my note. All right. Jesus Christ. Mr. Coger, I'm going to send you to a breakout room. Please accept to join breakout room. Number 7, Mr. McGee, join breakout room. Number 8, wait for the lawyer to come in to speak with you. Now, Ms. Teresa, you're not on my docket. Unmute and tell me what brings you to court today.
I'm on the case with Miss Howard.
What do you mean by that? You're the witness?
She's a co-defendant.
What's your last
I tried to look up Bragg.
Now, Mr. Flanagan, help me with that.
Ms. Bragg is set for a pretrial August 29th at 1:36 p.m.
You're not today, ma'am. Have a great day.
Okay, thank you.
Bye. Sir, you have to come in person. You have to, I don't even know what happened. Okay. Proceeding.
Respectfully, Your Honor, we are going to ask for dismissal if the complaining witness isn't here.
Ms. Ritter?
Judge, it's at least the second scheduling of the pretrial conference. The court did require the complaining witness, Ms. Regina Moore, to be present. I have not seen Ms. Moore logged into Zoom this morning, Judge, and I have no explanation as to why Ms. Moore is not present. So at this time, Your Honor, the people would not be able to proceed based on the complaining witness's failure to appear.
All right, today is the day set for pretrial conference. I need Ms. Page to be still. The complaining witness was required to appear. They have failed to appear. I need Ms. Page to be still. I need Ms. Page to sit up properly in the camera and to be still, please. All right, the complaining witness was required to appear. They have failed to appear. The people have no explanation for that failure. They are unable to proceed. The court is going to grant defense counsel's motion and dismiss the matter without prejudice for failure of the complainant to appear. We will mail you a copy of the order of dismissal for your record, sir. Have a great day and stay safe.
Thank you.
You're welcome.
Your Honor, for the record, Christina Ritter on behalf of the people. And Your Honor, I've just received notice that the complaining witness is inside the courtroom. Mr. Bauer, if you can come into camera view.
You want him to sit down? He can come up to the podium.
Oh, to the podium. Sorry.
Thank you, Mr. Bauer. Good morning. Can you state your name for the record, please?
Eric John Bauer.
Oh, how you? Okay, bless your heart. Mr. Flanagan.
Yes, Your Honor.
With respect to Ms. Howard, I need some more information as to why they're claiming that they're not representing Ms. Howard, I need more information.
Okay, I'll call him back.
All right, thank you. All right, Mr. Basant, your appearance, please.
Hey, good morning, Your Honor. Attorney Kevin Basant, P 71061, on behalf of Mr. Robert Chuka, who's also present by Zoom video.
And did you state your P number? I'm sorry.
I did, just 71061.
That's fine. Mr. Chuka, unmute and state your name.
You have to unmute, Mr. Chuka.
Unmute and state your name. Uh-oh, he might have froze up.
Robert Clifford Chupka.
Okay, he's a little frozen. Okay. This might not work, Mr. Basant. His signal isn't good. But today is the date set. Mr. Chupka, I need you to stop fidgeting with your camera.
Can you hear me?
Yeah, he can't. Okay. All right. Okay. I always wonder why people don't turn off their camera when they want.
Can you hear me?
We can, sir. I really need you to get somewhere and be stationary.
Okay, I had to move to a different area, that's all. Go ahead.
Well, thank you for your permission. Can you please state your name?
Robert Clifford Chupka.
Thank you. Today is the day set for final pretrial conference. Mr. Basant, how are you proceeding?
So, Judge, we did reach an agreement with the people. Mr. Chuka is prepared to enter a no contest plea for civil liability. He has been advised of his right to a trial in this matter. At this time, he wishes to waive that right and proceed with this particular plea. Is that correct, Mr. Chuka?
Yes, sir.
And he's pleading to what, Mr. Basant?
I believe the amended charge, and Ms. Ritter can correct me, but I believe it's attempted assault or attempted aggravated assault. Is that correct, Ms. Ritter?
Your Honor, that is correct. And a part of that plea agreement is a recommendation from the people for a term of probation, 12 weeks of anger management, restitution, if any is applicable, and no contact with Mr. Eric Bauer.
That's correct, Judge.
All right. Mr. Chupka, I don't know why your camera is fidgeting like that. Are you holding your device?
Yeah, I'm holding it out, yeah. Do you want me to look at it?
It's not stationary. It's not stationary. I need you to get stationary.
Okay, I'm stationary.
All right, your lawyer has indicated that you want to accept the people's offer and enter a plea of Ms. Ritter, that was the people's offer for no contest.
I'm sorry, Judge. Yes, the people have no objection to a no contest plea.
Right. Your lawyer has indicated that you want to accept the people's offer and enter into a no contest plea today. Is that what you want to do?
Yes, ma'am.
Sir, I'm going to share my screen, and on my screen is an advice of rights form. My question to you is, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes.
Okay, you're not going to be able to put your head down like that. So are you having difficulty hearing us?
No, I can hear you.
Okay, so I need you to not keep putting your head down. I need your face to be in the camera, okay?
Okay, no problem.
All right. So have you had an opportunity to review for yourself or go over with your lawyer your constitutional rights?
Yes.
Do you understand that by entering into this voluntary plea, you may be giving up your right to an automatic appeal? And if you were to change your mind about the plea, you would have to either request permission of this court to set aside your plea or request permission of the circuit court to appeal the conviction.
I understand.
Ms. Ritter.
Thank you, Judge. On June 6, 2021, at 1617 East McNichol Street in the city of Detroit, The complaining witness, Eric John Bauer, has filed a sworn complaint in this court stating that on the date and the location stated above, the defendant, Robert Clifford Shuka, contrary to law, did make an assault without being armed with a weapon upon Eric Bauer and did inflict a serious or aggravated injury upon said person without intending to commit the crime of murder or to inflict great bodily harm less than a crime of murder.
Then the court will accept the stipulation and in doing so will also accept a no contest plea to one count of attempted aggravated assault. Having accepted the plea, the court is going to set the matter for sentencing. Unless, is there any objection to immediate sentencing since the complainant is present today, or did you?
I would ask for an immediate sentence if possible, Judge.
All right, yeah, any objection from the people?
Judge, we have no objection.
Court is going to impose the following fines, costs, and fees. Mandatory cost of $210, a $250 fine. Additionally, the court is going to impose the following conditions. You shall not use or possess any illegal substances. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not drive without a valid driver's license. You shall attend 12 weeks of anger management through eBay. You shall submit to, strike that. You shall pay any outstanding tickets you have with 36th District Court. You shall clear up any warrants that you have anywhere. $890. The issue of restitution will close on October 5th. The issue of restitution will close. If I don't have any information about restitution, October 5th, then the restitution will be permanently set at 0. Anything further?
Just one question, so I'm just 100% clear with my client. I know we have a review date on October 5th, but the total amount of probation was it 12 months or?
12 months, yes.
Okay. And so, Judge, I'm just curious, does the court allow for early termination at the halfway point or not?
I do.
Okay, all right, thank you, Judge.
Yes, if he is eligible. But I didn't say that because I don't know allegedly how much if there's any restitution.
With restitution, understandable.
So if I order restitution, if he can't pay it by the halfway point, then he wouldn't get the early discharge. But I'm cutting it off on October 5th, so at least that would give him 3 months to pay if it's anything to be still eligible for the early. Well, he can get, he could be discharged at any point after 6 months.
Understandable, Judge.
Okay. All right, then we're all set. Everyone have a great day and stay safe.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video.